Welcome to Navigating Receiverships, a podcast from the Commercial Receivers Association, focused on building a better understanding of what brings companies into receivership, what happens in receivership, what makes them unique, some alternatives to receiverships, and ultimately, what happens to the business as the receivership is closed out. I'm one of your hosts, Eric Morcheski, CRA board member and CEO of Nimble Strategies. We're here today with Scott Moskol, partner at Blank Rome. Scott, thanks so much for joining us. Can you tell our
Thank you.
listeners a little bit about yourself?
Sure. So I started my career as a bankruptcy workout receivership lawyer, which is probably why you asked me to be on here. I did my first receivership in 1994, and I whisper it because it makes me feel really old. But I think it's important because receiverships are often a remedy that people kind of put off to the side because bankruptcy is more popular or whatever. But receiverships certainly have a is a strong weapon to use for secured lenders and with dealing with insolvency situations. Since that time, obviously, I've become very immersed in the cannabis industry. Myself and my partner Frank Siegel, we started our cannabis practice in 2013, and we are now co-chairs of the cannabis industry team at Blank Rome. As part of our practice, we represent operators, we represent banks, we represent lenders, we represent equity funds, VC funds, ancillary companies. And we made a conscious decision, probably right before the pandemic. We realized that, like any other new industry, there would be booms and there would be busts. And given that both of us had significant workout experience, we made sure that all our, like in the TMA or ABI, all our brethren knew that if they came across these issues, that we were here to assist. And it turns out that it was probably one of the better decisions, marketing decisions we made, because in the cannabis industry, I think we are certainly in a bust mode. And it seems like every other day there's another cannabis company that's filing for or being filed into a receivership, I should say. But what's interesting about the cannabis industry is that we are starting to see, because federal bankruptcy is not allowed, cannabis companies are actually utilizing state statutes to file themselves into a receivership. And that's a sort of a novel twist to the receivership world, at least for me. It's usually a secured creditor remedy. So,
There definitely are some that are putting themselves in, whether they're
yes.
cannabis or some other industries that we're seeing occasionally do it as well. Real quick, before we get into your specific receivership, tell us a little bit about Blank Rome in case people aren't as familiar with your firm.
Sure. So Blank Rome is a national law firm. We have about 800 attorneys in 16 offices across 13 or 14 states. Um, we are recognized for our financial and restructuring capabilities, along with corporate litigation, the whole 9 yards. Myself, my partner Frank Siegel, and our team came over here in 2024 from a mid-sized firm called Burns and Levinson. We went here because of its larger platform and its geographic breadth, and that has really allowed us to expand our practice, but also service our clients. So one of the cases we're going to talk about, the case we're going to talk about today is the Gold Flora receivership, which was filed in California. And whereas in our old firm, we might have had to hire local counsel, here we have an LA office and we have an Irvine office, and we're able to utilize two of our litigators who actually had a lot of receivership experience in the past as sort of our boots on the ground. And so I think that's what has really allowed our receivership practice to continue to expand.
So, kind of with that rolling into our topic today, tell us a little bit about what was going on in the industry, what some of the problems were that brought this company into receivership.
So, I think that the company we're talking about is Gold Flora. Gold Flora is what's called a single state operator. It had 16 or so retail stores, a grow, cultivation, and it wasn't that dissimilar from other companies in the industry that are facing, huge financial challenges, right? So there's oversaturation in the market. A lot of companies are in a race to the bottom to kind of preserve their position. Nothing any different than other retail operators, right? Leases are a little bit more expensive in the cannabis industry for a variety of reasons, including they could charge extra. There's a lack of institutional financing. So there are some banks that are providing capital, but far and few between. And this company had debt in excess of, I don't know, I think 20% or something like that. I can't remember the exact number, but certainly wasn't getting loans at 8% interest like other, non-cannabis companies. And, there's other factors like there's an illicit market. I mean, it's very rampant in California. Gold Floors, all of its operations were in California, and that creates issues. The state has been increasing the tax rate that's being imposed upon products, which is passed to the consumer. And so the consumer doesn't want to pay all that. So the average basket price kind of decreases, although the amount going to the taxing authorities increases. But another significant factor is cannabis companies are subject to a rule called IRS 280E. And what 280E provides is most cannabis companies cannot deduct normal expenses other than cost of goods sold. So, they can't deduct lease payments. They can't deduct utilities. They can't deduct employment, what they're paying their employees, go down the list. And so the effective marginal rate, because you can't deduct, is often 60% or higher. And in fact, in some instances where if it's only retail, sometimes, these are more like smaller operations, but oftentimes, although the company doesn't post a profit because of these unique rules, they are giving K1s to their investors, showing phantom income, because if you go through the whole tax code or whatever, if you can't deduct, then allegedly there's a profit, but there isn't. So that has caused a spiral for many of these companies. So I think in ways it's a perfect storm, for lack of a
It
better word.
really is. I mean, we've seen that in a number of our receiverships in the industry as well, that pretty much everything you just touched on. And 280E always kind of leaves me with a little bit of a puzzled look on my face just because I can't deduct the things that are legal, like rent or employees, but I can deduct the cost of goods sold, like the cannabis. Um,
Well, I will say I will go even a step further because I had this
yeah.
conversation actually when I was at the TMA conference last month, where I think it was a banker or a financial advisor was confused that wait, it's federally illegal, but yet you still have to pay taxes. Never mind the fact that you can't deduct. So, there's a lot of misunderstanding out there, but it does seem kind of odd that you could pay full taxes, but you don't get treated like every other taxpayer in the Commonwealth. Oh, not the Commonwealth, where are we? The United States. So,
Yeah. Yeah. So diving in then, this company got brought to you. I think you, in this case, you represented the receiver, correct?
so in this
Or,
case, so we had represented Gold Flora
uh,
traditionally for the last 2 or 3 years. What happened was Gold Flora was facing a perfect storm of creditors. They were facing a potential another alternative receivership process. They were stuck in a series of litigations that were more legacy litigations from a company that had purchased a few years prior. And so again, we hate using these types of cliches, but there is no better cliche than a perfect storm. So under California, in fact, most states have a statute where the state corporate or LLC codes allow for a company to file itself into a receivership in aid of a dissolution or liquidation. And so that's what we did with respect to the Gold Flora entities. We threw ourselves into a receivership. Richard Orman from Stone Blossom was named the receiver, and as company counsel remained to assist the receiver in various issues, a lot dealing with financings and the sale of the company's assets, which was the primary focus of the case, to sell the assets, preserve value, and do what was needed to really protect the assets, but also the employees. as opposed to having this dissolved and really have no value add to anyone. By preserving this as a going concern, we protected, hundreds and hundreds of jobs. And that is something that I think people forget about receiverships, that if done correctly, yes, the owners aren't necessarily going to get repaid, or paid at all. Usually equity doesn't. But if we can preserve jobs for people, that's something that is important. And I say this to all my younger associates when they first start working on a case like this, like, don't forget, yeah, we're filing all these motions and drafting all this corporate papers and blah, blah, blah. But at the end of the day, you're saving 500 people from going on unemployment potentially. And so, we're actually doing something I think helpful for society, despite the fact that, we're going through an insolvency judicial proceeding. And I'm sure, Eric, you as a receiver, you see this all the time and kind of feeds the soul.
Yeah,
I,
I mean, we usually have to go in and I find myself saying it a lot. Look, like we didn't create the problem as the receiver. We're here to fix it as cleanly as we can. We can't promise that everyone's going to keep a job after a new company comes in to run it, but we're going to do our best to keep as many people employed as possible.
And we
Um,
ripped it. We had to rip people, right? I mean,
yeah.
there's no alternative. A lot of times, there's probably should have had a few layoffs prior to the filing of the receivership.
Mhm.
But, at the end of the day, if you can preserve 75% or more, I mean, that's important.
Yeah. Yeah, and I mean we've had some where we've sold it and companies have bought them and grown them, and so the jobs have just gone up, not down. So I mean
Yep.
it varies obviously case to case, and in this case, you're in a unique position because you came in to a company that you and your client had historical background in. You're basically
Right.
the plaintiff and the defendant, and then engaging the receiver. Presumably, there was not a huge fight over who the receiver was because you were
Right. Right. Although
representing the entity.
we have represented secured lenders in
Yeah.
these instances. Some are disputed and some aren't so disputed. And, you know, I think one of the bigger problems in selecting a receiver in the cannabis industry is there are so few receivers who have that type of experience. And I'm not saying that, you, Eric, couldn't learn the industry on the fly, but there's a lot of peculiarities. Like cannabis, if you think about it, it's an agricultural play because they grow, it's an ag company. It's a retail play
Mhm.
because they're selling to consumers. It's a consumer product play if they have brands that they're trying to create, and it's a real estate play. And so
Manufacturing, like, I mean, yeah,
keep on
there's
going
all,
down the list.
yeah.
I mean,
I
it's
mean, yeah, it covers everything if they're fully vertically integrated, and it makes it to where, it's rare that one person's going to have all that knowledge, and a
right.
team can be the critical component to
Agreed.
ensuring success. Yeah.
And I
Uh,
know you are doing, you have learned and you have done cannabis receiverships as well. And there's really a short list across the country. Also, a lot of traditionally receiverships were for real estate, and it's only slowly it's become a remedy for operating entities. So a lot of that experience is missing in terms of you got to not only do you know how to sell real estate or collect rents, right? But you have to know how to operate this company, or at least know who to ask how to operate the company, and like learn the lingo and learn the industry, which is can be difficult and trying.
so with Gold Flora, you did have this vertically integrated,
Yes.
and you did have all of these, like you said, maybe 500 employees. What what actions were taken to make sure that you could ensure that as many people could keep their jobs as possible? What actions were taken that could help ensure secured creditors were paid back? What happened in the receivership?
So, in the receivership, this was in many ways a unicorn from a receiver perspective because there was not one senior secured that had a lien on all the assets. So someone had 2 million here and someone had 3 million there. As more often than not, there's one behemoth or 800-pound gorilla who
Mhm.
has a lien on all the assets and so is approving budgets and whatnot and has a lot more control because it's their collateral. Here we didn't have that so as much. And so we were able to really blaze our own path. Like we didn't need to have anyone approve budgets per se. But I will say this, the company was struggling with cash flow, and we were able to obtain a $10 million receivership certificate. East West provided the financing, and we were fortunate, right? Because it's difficult for an insolvent entity to obtain credit, in the best of times. Here in under California law and practice, the receiver certificate, it's equivalent of like a dip loan in bankruptcy, got super priority, senior secured status, and you had to bring a motion before the court, which the court granted, but that debt facility was paid before anyone else. And
Mhm.
so that was the protection offered to the lender. I will say this, not all states have that similar practice. And so you got to be careful whether you're filing yourself or pushing another entity into the receivership, make sure they have cash reserves. Frankly, in some states, if the estate's administratively insolvent, the petitioning creditors can be surcharged for the amounts, at least for the receiver and the receiver's counsel and other professionals,
Mhm.
not the administrative expenses. So
Yeah. So East West stepped in and
Wes stepped in and so essentially this was a sale case, as most
Mhm.
receiverships are. I mean, we had to work to stabilize, the operations. There were certain leased locations that we determined just were losing money there. Even though we weren't necessarily paying all the rent, we're still losing money. And so we, made the executive decision, or the receiver made the decision to terminate some of them early and to give it back to the landlord since we would either be evicted or just didn't make economic sense. But overall, this was an attempt and became a successful attempt to sell all the assets as a going concern. And so, traditional sale process, we hired an investment banker. They went out to market. We chose a stalking horse. We had a bid protections. We had an auction. At the auction, another party came out and there was a spirit auction that drove the price up. And at the end of the day, one lost and one won. And fortunately, the bulk of the assets were sold to this one company intact. And while Gold Floor, the name doesn't necessarily live today, its operations do. And those folks who are employed there still have jobs. And that's really important.
yeah, I mean, it seems like you got about as good of an outcome out of it as you could have hoped for, especially, if you had jumped back to, 2 weeks before filing, to that. I feel like it's one of those where you go, man, like I don't know that we could have guaranteed this type of outcome.
No, I think also we were lucky that some of the alleged secured debt had issues with their priorities or perfection, I should say.
Hmm.
And like I said, we didn't have someone who had like a $50 million lien. And so we had a little bit able to navigate in between the issues. Um, Whether it was truly successful would have to depend on the bulk of the creditors because we are finalizing, kind of ending the creditor process and claims process. Now that the sale has closed and money's in
Hmm.
the till, depends where you are in the pecking order, how successful it is. I think most of the allowed secured claims are being paid in full. Administrative claims have been paid, but there's money owing to the taxing authorities. It's not unusual, as well as to multiple unsecured creditors and landlords for pre-petition rents and whatnot.
Yeah. Yeah.
So
Well,
I mean, yes, it was successful in sort of like the global perspective of receivership world, but don't want to minimize that some folks lost significant amount of money.
for sure. And there's always the group of equity holders that believes the
Oh,
company was still completely solvent and,
yes.
should have sold for 100 times their, their investment value and and
I will
everything else.
say this, in other receiverships, whether cannabis or non-cannabis, there's always questions of was there, mismanagement by the board or the C-suite? Was there self-dealing? Was there, go down the list. I'm sure have contemplated having to bring suit. Here, this was clean. And I say clean because not only none of the creditors came and said a demand saying, hey, the board stole the company, stole money,
Mhm.
fleeced the company. Can you go after them or something like that? So again, maybe a unicorn in that we had a clean company to begin with. I mean, in fact, at the time of the filing, I think the board was owed hundreds of thousands of dollars that in past board payments that it just company didn't make. So if anything, they had a claim as well, which
Yeah.
anyways, but
Yeah. So you've wrapped up the sale. You're kind of at a point where you believe most of your secured creditors are getting paid. What were kind of some of your takeaways from this case?
I think one is, and I think this is true for any receivership, is you got to be flexible and you got to roll with the punches. I know, again, cliche, 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 but it's true because it's a judicial forum. You never know who's going to come out of the woodwork to utilize that forum. So, like let's say you were doing a foreclosure, Article 9, whatever, go down the list. There's not a judge, there's not some place to air your grievances. You maybe go file the Superior Court or whatnot, like some type of collection action. But here, where you have a judge overseeing the entirety of a proceeding, similar to a bankruptcy, certain people filed things that were surprising, and we reacted and responded. And so you do need, like, yes, you have a plan, but you got to be ready to weave in and out and get to the other side. I think with cannabis, one of the other sort of issues people need to remember is, there aren't that many buyers, true buyers out there with cash. So in the cannabis industry, outside of a receivership, the general rule of thumb is that a sale will be paid in a component of cash, equity, and note payments, right? But here in a receivership, when you want to close the estate as quickly as possible, taking a 3-year note doesn't make sense. Or taking stock that there would be restrictions on when you can sell it and or if you could sell it, given a lot of these companies' stock are not very liquid. So finding that buyer that has, the cash reserves where they have in the, their bank account or they're getting a loan is extremely difficult. And so you got to really have an understanding of the market and try to help vet who's a real player and who can come to the plate.
Yeah, I think that's a really good point because you're not looking for I stepped into one cannabis receivership that a receiver had to step away because of health issues. And so I stepped in
Uh,
right as he was about to file a sale motion. And his sale motion was basically a seller finance deal for years of payments. And it was a bad deal, right? I mean, it was, but he also was going through chemotherapy and all kinds of other
sure.
things. So may not have been thinking clearly when he went through it. And so we kind of were like, yeah, sorry to tell you, but we're not taking this to the courts. And we did end up with a cash deal. But I also think the other thing with yours that's a little bit unique is at scale, small scale, you might be able to find a cash deal easier than when you get to
Sure.
these larger,
Tens
500
of tens of
employees
millions of
and
dollars. Yeah,
fully
exactly.
vertically integrated and all these locations. The larger it gets, the harder it is to find enough cash to cover that. But when you've got, a retail operation that's just a retail operation and nothing else in
Sure.
receivership, you might be able to find a buyer for that with an all cash deal easier.
Although I will say that I find it more common than not when you're selling like a single retail operation or like a company with like two small dispensaries or whatnot. It is more and more common to see being fully seller financed because people who have the cash aren't necessarily going to take that risk per se. And so you're going down the rungs of like qualified bidders, for lack of a better
Yeah.
word. And you know, maybe it was because your predecessor was ill, or maybe you got lucky to find some of the cash. Or I don't want to say lucky, but you
Well,
persevered,
luck
so you
plays a
got
role in it for sure, right?
yes,
When
yeah.
to go find the right buyer at the right time, because timing is everything. There is a bit of luck for all of us in it.
There's a lot of luck, I think. I
Yeah.
mean, our stalking horse we found kind of at the 11th hour. There
Mhm.
were some other parties that we're talking with that, may have had like certain contingencies, and then we were able to find our stalking horse, and the stalking horse won. One thing I do want to say, just generally in receiverships, a lot of people think that if they aren't the stalking horse, if they're going to be that type of process, oh, they're never going to win. But I have found like 50-50. Sometimes the stalking horse wins, sometimes it doesn't, and kind of go from there. So don't be discouraged, people, if you aren't the
Yeah.
stalking horse, I guess
No,
is
I'm actually
the other
trying to think. I
moral.
don't remember the last case I had that the stalking horse was the ultimate buyer. So,
Right.
so I have
Because
the opposite of popular opinion. So, what should our listeners take from this case if listening through this? What do you think are some kind of critical takeaways that people should benefit from? I think I've heard a few from you already throughout this. One is, making sure that people have experience in the industry when they're getting into the receivership
yeah,
space for cannabis, because it is a little bit unique. It's a lot unique. It's not even just a little bit.
right.
But
Also, it's federally illegal,
yeah,
so technically, all of us are committing a federal crime. We're
yeah.
in a conspiracy to aid this, sale of controlled substances, but it's not for the faint of heart. I think, receiverships, insolvency work, bankruptcy work in of itself can be incredibly frustrating and difficult because, you think you're going along this path, and then, four different people file objections or motions, and you're like, what are they thinking about? But definitely having that understanding of the industry is helpful. A lot of times, because we represent buyers in other deals, we've been able to make introductions to some of our clients or people that we know, to the investment banker. It helps of furthering the deal. And so, industry and understanding of the industry just in general, I think is kind of important. Not saying you can't learn it on
Mhm.
the fly, because you can in times, but you better learn quickly. I think you probably would agree on that one too.
Yeah. I had the first cannabis receivership in Missouri. There were no other Missouri receivers at that time that had experience in it.
I think
Like,
actually that brings up a really good point. So we got the first cannabis receivership in Massachusetts.
hmm,
Massachusetts doesn't have a receivership statute per se. It
yep.
was more common law. But the problem was, and the problem is in some other dealings we're having, um, you have to educate the courts, right? So not only do you have to educate the courts as to like how do we normally do these receiverships? What's bankruptcy law? I had a case where the judge had said, "Well, I haven't had done the only receiverships I've done in the past dealt with liquor licenses," and I'm like, "That's not apples to apples, or more like apples to concrete." But also, you have to educate the judges about cannabis, about the industry, but also about the regulatory framework, right? So different, well, not in healthcare, you have some of similar issues, but like there are licenses that are issued. And those licenses to transfer, you have to go through a set of approvals. Sometimes the approvals are necessary at the state and as well as the local community, like municipal level. And, explaining to the judge, we're going to do a sign and then close like 4 or 5 months from now, while keeping status quo, hopefully. It's just something that, it's not familiar to them or common, or they've ever dealt with. And then, regardless that it may be legal in certain most states, there's still a stigma attached to it. And there's a lot of misconceptions. Like we've had to educate judges that yes, cannabis companies can have bank accounts at federal and or state chartered banks, that are FDIC insured or NCUA insured. And, simple things like that, which you and I take for granted in terms of knowledge, like all of us know this stuff. Judges don't. And I think, you know, thinking about this more, I think whether you're a receiver, a lawyer, Cowan investment bank, wherever you are in the sort of hierarchy or the professional stack, let's say, you are going to have to take some time to educate the court. And it can be frustrating at times, to be honest, because you're like, well, I've done 10 of these. I know I'm an expert because, you and I are, but the judge is still the judge, and you have to make sure you don't outshine the judge while
Yeah.
educating.
Well, and it's not, from my perspective, it's not just the courts. Like after our first cannabis receivership, we sat down with the Department of Health and
Oh,
Senior Services in Missouri, who runs the cannabis in
yes,
Missouri, and talked to them about what is a receivership and what their role is and what their rights are so that they could better understand it. Because what we
yes.
didn't want is for them to just come in and be like, this is a change of ownership and therefore we're revoking the license for us or
Well,
for anyone else, right? And it's not a change of ownership. I don't own it,
right.
but
I mean,
I mean, it's essentially it's not dramatically different than like the MSAs that most states will approve in a heartbeat. It's just the court is taking control while this goes on, and so we wanted them to feel more comfortable. So again, it's not just the courts; it's all the government entities involved, making sure that they're on board and understanding of what's going on and how they can exercise their own rights.
and
Because I think
also, oh, sorry, go ahead.
Oh, I think that makes them feel more comfortable, hopefully, with the process.
Agreed. Agreed. I mean, we're dealing with other cases right now where we're kind of having to educate the regulators who are trying to hit us for fines that happened years ago that you can't technically, there is a separation of, governmental executive branch and judicial, but like these are the rules that it's pre-petition and why would you don't have a lien. But also, I think some states, their cannabis regulations require a receiver to be pre-approved before the court approves them. So I know we've dealt with that in Massachusetts and Maryland, for example. And, it's kind of difficult to tell a judge this person hasn't been approved. We don't like them anyways, but it hasn't been approved, and you should go with like Eric because he has been approved and he knows what he's doing. So,
Yeah.
um,
After the first one, I tried to argue that you should have to be pre-approved in Missouri, but that would have been a short list of just me at that point.
well, but that's
So I
but
thought that
that's
was a great
the
idea.
Oh, no, but many states do have that
Mhm.
requirement. In Nevada, the receiver had to get approved not just by the court, but by the Nevada regulators, for example,
Yeah,
in the case I did there.
and that's
And
what had to happen in Missouri as well.
sure,
Yeah.
and so like you're not just seeking approval from a judge, like you said, it's important to kind of
Mhm.
communicate with the regulators, give them as much advanced knowledge as you can, but also you got to know those dang rules and work with them and work within that framework. And if it says you need to be pre-approved, well, you need to be pre-approved because under the regulations, it may not be a change of ownership, but certainly a
Mhm.
change of who's in charge, who's in
Yeah.
control, which also requires regulatory approval in most
Yeah.
states.
Yeah. Well, thank you so much, Scott.
Sure.
This has been great. I really appreciate you
Thank you.
doing the episode and kind of talking through, your own experience in this and in the Gold Flora case, as well as some of your other experience within it. I also think you may be on my list of phone calls the next time I'm selling a cannabis operation.
Definitely. No, you should. No, seriously, you should.
Yeah, so you might be a popular guy.
Well, it's a very tight-knit industry. People like another cliche. Okay, that's gonna be that's probably you'll title this the many cliches of Scott Moskal. But instead of 6 degrees of separation, it's probably two in cannabis
Mhm.
for sure. So
Yeah.
call
Well,
away.
and Missouri's kind of that way too. So there's like 2 degrees of separation to every, person in St. Louis. And so when you factor the two together, it becomes even a smaller group here. Yeah. So, well, thank you so
Oh,
much for
thank you
doing
so
this.
much. No,
Yeah,
thank you. This is
this is
fun.
great. Thank you.
All right.
Thank you for joining Navigating Receiverships, brought to you by the Commercial Receivers Association. Find more information at commercialreceiver.org and catch every Navigating Receiverships podcast by subscribing through your favorite platform today.